She betrayed him mid-trial. In 1946, a prosecutor's star witness switched sides on the stand. What happened next created America's most dramatic legal loophole. Before 1946, American courts operated under a sacred principle. You could never attack your own witness. Think about it. You called them. You vouched for their credibility. Questioning their honesty would be like admitting you brought a liar into court. But here is where it gets strange. What happens when your witness walks into that courtroom and says the exact opposite of what they told you before? You are trapped. You cannot challenge them. You cannot ask leading questions. You cannot do anything except watch your entire case collapse. The prosecution had spent months building their case. But that was nothing compared to what was about to unfold in that Chicago courtroom. The case involved a warehouse fire that killed 3 workers. Prosecutors had an eyewitness. A woman who had given a sworn statement identifying the defendant as the arsonist. She had been certain. She had been detailed. She had been convincing. But here is what nobody expected. When she took that witness stand, something changed. Her voice wavered. Her eyes avoided the prosecutor. And then she said 4 words that sent shockwaves through the courtroom. I do not remember. The prosecutor objected. The judge sustained. But it did not matter. Every follow-up question received the same answer. I do not recall. I am not sure anymore. That was a long time ago. The prosecutor was watching his case die in real time. If this is already changing how you see trials, drop a like. But here is where the story takes an unexpected turn. The prosecutor did something desperate. Something no attorney had successfully argued before. He stood up and said 3 words that would change American courtrooms forever. Your Honor, hostile. The judge paused. The defense attorney shot to his feet objecting. But the prosecutor pressed on. He argued that this witness had clearly been gotten to. That her prior sworn statement proved she was lying now. That justice itself demanded he be allowed to challenge her. And this is where it gets truly fascinating. The judge had a choice. Follow centuries of legal tradition. Or acknowledge that sometimes witnesses betray the very people who called them. The courtroom went silent when the judge made his decision. The judge declared the witness hostile. For the first time in recorded American trial history, a prosecutor was granted permission to cross-examine his own witness. To ask leading questions. To challenge her credibility directly. To treat her like the enemy. And then the real drama began. The prosecutor pulled out her original sworn statement. He read it aloud line by line, each detail she had provided months earlier. Each identification she had made with certainty. Then he asked her point blank. Were you lying then or are you lying now? The witness broke down. She admitted someone had threatened her family. She admitted she had been paid to forget. She identified the defendant once again. But the defense made a fatal mistake that would cost them everything. But everything I just told you was only half the story. Because this ruling did not just help prosecutors. Defense attorneys realized they could use it too. Think about that for a second. What if you could call a witness you knew would be hostile just so you could cross-examine them immediately? What if you could force the other side's best witness onto your witness list, then declare them hostile and tear them apart? This is where the real manipulation began. Lawyers started weaponizing the hostile witness rule. They would call witnesses they had no intention of using fairly. They would provoke witnesses into hostility deliberately. They would turn direct examination into a battlefield. And if you think that sounds like legal warfare, subscribe, because what comes next is even more disturbing. The hostile witness rule created 3 specific powers that attorneys still exploit today. First power. Leading questions. Normally on direct examination you cannot suggest answers. You must ask open questions. But with a hostile witness you can put words directly in their mouth. Did you not tell investigators the defendant threatened you? Second power. Impeachment. You can directly attack your own witness's credibility using their prior statements, police reports, even their criminal history. Third power. Control. The witness can no longer give long rambling answers that muddy the waters. You can cut them off. Redirect them. Dominate them. And this is where justice was served or corrupted depending on who wielded these powers. Drop your thoughts in the comments. The hostile witness rule fundamentally transformed what a courtroom actually is. Before 1946, trials were about presenting your best evidence and hoping the jury believed you. After the rule, trials became psychological combat zones. Attorneys learned to read witnesses like chess opponents. They studied body language. They analyzed speech patterns. They identified pressure points before ever entering court. The 3 workers who died in that warehouse fire finally received justice when their killer was convicted. But the mechanism that made it possible has been used and abused thousands of times since. Some convictions that should have failed succeeded because prosecutors weaponized hostile witnesses. Some innocent people walked free because defense attorneys knew exactly how to trigger the rule. The truth became secondary to technique. Today the hostile witness rule exists in every American courtroom. Federal Rule of Evidence 612 codifies it. Every state has adopted some version. And attorneys on both sides consider it one of their most powerful weapons. But here is what most people never consider. Every time you watch a courtroom drama and the lawyer dramatically confronts their own witness, that is this rule in action. Every time a real trial hinges on witness testimony, that power struggle traces back to one desperate prosecutor in 1946. One betrayal. One creative legal argument. One judge willing to break tradition. That is how American law actually evolves. Not through grand legislative battles, but through single moments when the old rules simply stopped making sense. And the next time you serve on a jury, you will recognize it the instant it happens. Now you understand how one courtroom betrayal in 1946 created a rule that attorneys still weaponize today. The hostile witness exception transformed American trials into psychological battlegrounds where the truth is whatever the better tactician can prove. Subscribe for more courtroom breakdowns that reveal how the legal system really works. What trial tactic should I expose next? Tell me in the comments.